Idaho. Of course, I really miss being up north in Moscow, Idaho, my old stepping grounds. Many will remember I fondly talk about those 3 years I spent up there teaching at our main law school campus. My name is Shaakirrah Sanders. I am a professor of law at the University of Idaho College of Law. I teach constitutional law, criminal procedure, and the First Amendment. I want to thank the Black Student Union for inviting me to give this lunchtime conversation or lecture. And I want to congratulate the Black Student Union on their 50-year anniversary. That is so exciting. It is such an amazing achievement. And I look forward to celebrating this throughout the rest of the year, whether we are on Zoom or in person. And I want to thank the leadership of the student union with all of the stresses of COVID, classes during COVID, all of the other things that come with the quarantine, the medical pandemic, the political pandemic, the social pandemic. I just think the students have done such an amazing job to bring awareness to such an amazing achievement for this student organization. I'd also, of course, like to thank the Office of Multicultural Affairs for putting this series together and providing all of the technical support for today's program. And also, as always, for your office for making me feel very welcome and welcoming my conversation. So what I wanted to talk to you today about is Idaho House Bill 440, which is now a piece of legislation that you can find at 67-5909A of the Idaho Code. Again, that is 67-5909A of the Idaho Code for any of you who want to look that up as we're walking through our conversation. What I'd like to do is talk about the legislation itself, what it contains, talk about how there's U.S. Supreme Court jurisprudence in this area that could affect a court's interpretation of this statute, and then talk about how we, as members of the University of Idaho community, and what we can do despite this legislation or because of this legislation to improve diversity, inclusion, and equity in our communities, not just up in Moscow or down here in Boise, but for all of our statewide campuses. In addition, because of our status as the land-grant university, I think this is also an opportunity for us to model for other universities around Idaho about how to use this legislation to increase diversity, equity, and inclusion in our state. We're fond of saying that we're the Idaho leadership in education, and I believe that about our institution. And so I think in this area too, we should be the models on diversity, equity, and inclusion. So for those who do not know, HB 440, House Bill 440, was passed last legislative session and signed over the summer, I should say at the end of the session by the governor into legislation. So what does this piece of legislation do? Well, one, it is entitled, it is a new section to the Idaho Code, and it prohibits certain acts. It prohibits discrimination as well as preferential treatment in public employment, public education, and public contracting on the basis of race, sex, color, ethnicity, and national origin. So let me say the criteria again. We have a piece of legislation that prohibits discrimination and preferential treatment in public employment, public education, and public contracting on the basis of race, sex, color, ethnicity, and national origin. Now, when I read that list, I note that there are some omissions that I am accustomed to seeing in legislation that prohibits discrimination, and I'll talk about that later. But in general, just to give you a little peek, I notice that we don't have anything that prohibits discrimination on the basis of religious belief. Usually you see that in an anti-discrimination statute. But as it pertains to the education environment, I also note that this legislation does not prohibit discrimination or preferential treatment, not just on the basis of religion, but legacy status, i.e., do you have relatives who went to the institution? Geographic location, whether that is in state or out of state or via counties in our state, and other type of factors. And to me, I find that a little curious because, again, when you look at similar anti-discrimination statutes around the country, including federal anti-discrimination statutes, it does not only focus on race or sex. And of course, with race, you have the closely correlated color, ethnicity, and national origin. And I think that is actually quite important should this statute ever be challenged in a court of law. It actually could be very fatal that we seem to limit ourselves to a certain number of categories. But what else does this statute do? That's just the first part. One, we see here a carve out. The statute says that this section shall not be interpreted to prohibit bona fide qualifications based on sex that are reasonably necessary. Very curious there. Given all of the US Supreme Court jurisprudence I read on gender, I do not know of any that has approved or know of any that really talk about what these bona fide qualifications are based on gender. And the way this is written, that's rather broad. I do wonder what the scope of that entails and who makes the decision about whether or not there is a need for a bona fide qualification based on sex. I also wonder if a carve out like this, because it focuses on sex, whether there could also be reasons to find that there's a suspicion with regards to the motivation of this statute. Usually when you have a series of a statute like this that has a carve out that only focuses on something that again is a suspect classification factor, you don't always see it sort of highlighted like that. So I do wonder if that will ultimately cause a court to look deeper at some of the motivations about this statute. We also see here that the statute says, hey, if there's a court order on this, the statute is not going to affect that. We see a definition of who qualifies as the state, a pretty broad definition, certainly includes our public university. We see here a section with regards to remedies, and here it says the remedies available for violation of this section shall be the same regardless of the injured party's race, sex, color, ethnicity, or national origin as are otherwise available for violations of this chapter. I think that relates to other parts of the series or the title that this particular statute belongs with. And here in our last section of the statute, we see that if the US Supreme Court or if this statute is found to be in violation of the US Constitution, then we have our normal provisions that say we'll try to preserve as much of the statute as we can as possible. So I'd like to focus the rest of my conversation on the beginning part of this statute. It's anti-discrimination prohibition. And the first thing I'll say on that is that it does appear that the statute equates discrimination with remedying discrimination, or I should say that's a question that I have about this statute, right? And the way in which it prohibits discrimination and preferential treatment, well, that causes me to have some questions because the US Supreme Court has approved of remedies and the use of race or gender or other suspect classifications as a way to remedy past discrimination or actually remedy current discrimination. And so I am not sure if this statute is actually prohibiting the use of these factors, race, sex, color, ethnicity, and national origin. I'm not sure if we could use those if there is a violation or if we find there is a violation. And I'll talk about why that's important given US Supreme Court jurisprudence. So In the mid-1970s, the US Supreme Court decided a case called Bakke versus the Regents of the University of California, Berkeley. Bakke was an applicant to the medical school at the University of California who was denied admission. And according to the case, Bakke was a white male. And he brought a lawsuit and made the argument that were he not a white male, he would have been admitted to the medical school. Now, there's some interesting facts of this case that I won't get into about whether or not people felt like Bakke had the requisite attitude and personality to really succeed as a doctor. That's not really that pertinent to this case, although I do find it interesting, the type of rationale that the school used as a way to say, well, we actually did look at this applicant's qualifications, and regardless of who he was, right, he would not have been admitted to this medical school. What I'd like to focus on is the part of the court's opinion that looks at the use of race, gender, and other suspect classifications as a way to diversify colleges and universities. Now, contextually, this is a US Supreme Court that is deciding this case at a time that is several decades after the decision in Brown versus Board of Education, but also when many places are still resisting the court's order to desegregate K through 12 public education. And of course, prior to Brown versus Board of Education, the court had already ordered a number of colleges and universities to diversify their graduate and undergraduate programs. And yet, by the early 1970s, achievement at colleges and universities for African Americans and other people of color is still very low. Or there's a level of underachievement. And many point to the failure of states to diversify their K through 12 education. And many also pointed to the lack of comparable schools for students of color in public schools around the country. Of course, we do know that that continues today, that students and children of color in our K through 12 public schools do not go to as great of schools as other children, that they often live in segregated environments, mainly urban in many places, and that their parents are more likely to make less than their white counterparts, despite the fact that there may be equality in the levels of education. And guess what? Even today, that people of color who earn very good livings still live in poorer neighborhoods than their counterparts. Many point to the continued existence of housing and to other discriminatory practices in housing for these type of results. But of course, I've gotten too ahead of myself. I am talking about Bakke versus the Regents of California. And there, what the court ultimately held is that in order to increase diversity in colleges and universities, it is possible to take race, gender, and other factors into account. Now, the court makes clear that you cannot set a quota or have some other preset percentage of individuals that you are seeking to attract to your institution. But again, the court makes clear that there is nothing wrong with using race, sex, gender, and other suspect or special factors when considering admissions to colleges and universities. And those other factors can include things like geographical location. They can also include things like whether your parents ever attended college, positively and of course negatively in the way we've seen in admissions. So here, in the wake of Bakke, what we did begin to see is that colleges and universities took gender, took race, and took other factors into account as a way to diversify their campuses. And this practice was generally accepted until the late 1990s when we got two cases out of my home state, Michigan. Of course, I am talking about Grutter and Gratz, both of which affirmed again the use of race, the use of gender, and other suspect classifications as a way to diversify colleges and universities. Now, using race as a way to increase diversity is not the only approved method or way that you can use race in your admissions process. If there is evidence of past discrimination, the court has also approved the use of race. And here again is where I say it is unclear to me whether this statute is equating remedial measures or measures to improve diversity with discrimination and other types of illegal preferences. I question that because this is the distinction that the US Supreme Court has made with regards to the use of race. And so to the extent that the US Supreme Court says, hey, there are a narrow set of circumstances where you can take these things into account, then I wonder how that last part of the statute interplays. Does this statute now conflict with the US Constitution to the extent that it has been interpreted by the highest court, our US Supreme Court? So as I mentioned, the use of race in college admissions was greatly accepted, and that we had challenges to this in the University of Michigan cases, Grutter and Gratz. And my apologies, I just want to make sure I have my clock in front of me. So both of these cases challenged admissions programs at the University of Michigan's law school and their undergraduate school. And I want to talk about these because I think they provide a good contrast for the type of admission practice that the court has approved and the type of admissions practices the court says are not okay. And so if you look at the undergraduate program at the University of Michigan, the program that was at issue was one that allocated a certain number of points to applicants based on race or gender or some other factors. Now, the challenge, of course, only involved the use of race. And so that's what I'll focus my remarks on. So in that case, I think the undergraduate university had allocated something like 20 points based on the applicant's race. And their application or their admission scheme had this sort of, it took into account test scores, GPA, your personal statement, all of these different things. And part of what that process was as well is that for certain students who fell below a particular threshold, the university would sort of go back and do a review and say, well, is there other reason maybe to allow these students in? And it looks as if you could get that, most of that second review were for students of color. And so there, part of what the problem was the way in which the admissions program isolated certain students. It did not consider all of the students as a whole. But the other problem was the way in which the program allocated a certain set number of points based on race, regardless if you needed those points to get into the school or not. And so you could have a high achieving student of color. They would still get the points, right? Even though their test scores and all of their other factors would have qualified them for admission. Because of the way this happened automatically, I think it made it too difficult for the undergraduate program to make any type of claim that they needed to allocate these points in order to get a diverse class of students. Because again, students of color who didn't need the points to get in got them as well. So in that situation, the court says, your undergraduate admissions program was unconstitutional. You could not show that your use of race was necessary, nor could you show that it was the least restrictive way of achieving your diversity goals. But the court did approve that the diversity goals were legitimate. The court did say that you can still use race. We just don't like the way you used it. It was your methodology not your purpose, that was incorrect. With the law school's admission program, the court found both the purpose and the methodology correct. For the law school, there were no set of points that you received on account of race or gender or any other factor. And the law school's goal was to achieve a critical mass of diverse students. Part of what the law school argued is that when you have too few diverse students in the classroom, that can lead to feelings of isolation. It can also increase the type of aggression that you feel as in that isolated space. Finally, it makes the student feel as if they have to account for everyone of their race or gender or ethnicity if they are the only one. And so here what the court says, it is okay to use race in your admissions program if it is necessary to help you achieve a critical mass of diverse students. Why? Because that will increase not just the diversity of your campus, but the education experience for everyone in the classroom and campus-wide. The court recognized that it's only with the diverse education that we can achieve the best type of education that our country has to offer. And the court offered no doubt on the legitimacy of diversity as a compelling government interest in public education. Now, of course, neither one of these cases go to that other factor where you have evidence of discrimination and you want to use race in that way. But based on the reasoning of the court in these education cases, I find it very hard to believe that if there is evidence of discrimination, that you cannot take race into account in order to increase diversity at your school or within your faculty ranks. Now, taking race, gender, or any other factor into account is not to say that an individual is unqualified. What it means is that you are taking into account the benefits that will be derived to your campus by having more diversity. Diversity of thought, diversity of appearance, and diversity of life experience. Now, I want to quickly say that the court has recently affirmed the use of race as one of many factors in college education. This is a set of cases dealing with the University of Texas admissions program. There they've had a program where the top percentage of every school gets into their choice of state universities. And after taking other factors into account, they use race. And there again, the court says, diversity is a compelling government interest in public education, including at colleges and universities. And it is okay to use race, gender, or other factors when trying to achieve a diverse group of students for your campus. Now, again, that case did not deal with issues where if you have evidence of discrimination, but again, the reasoning of that case, the benefits of diversity, and the need to prevent isolation for students of color and others leads me to the conclusion that it could be okay to design a program that can pass constitutional muster and that also takes into account factors like that which is prohibited under Idaho's statute. Now, what type of measures am I talking about? Well, one, I think we really do need to evaluate for our community whether we have a critical mass of students. And I don't think there's anything wrong with us conducting a study to do that if people are willing to do it voluntarily. What does that mean for our community? I don't think there's anything wrong with us to conducting studies and conducting surveys, to root out whether there is a history of discrimination at the University of Idaho, statewide. And of course, I think people would be more than happy to voluntarily participate in these programs. Look at the number of people that we even have here today after such short notice, even of this program. What else can we do? I think there is nothing in the statute to stop us from having more conversations like this to discuss the benefits of diversity and inclusion at our institution. And I certainly don't think there's anything in this statute that should stop us from, as part of those conversations, recounting our own experiences in our community with regards to diversity and inclusion, discrimination, and harassment. I don't think there's anything with us creating affiliation groups to provide support and professional allyship to members of the community who need it. All of the measures that I just mentioned have been shown to improve culture and climate in communities like ours. So I'll ask you, what are we afraid of? Isn't it time that we evaluate and improve our culture? It can never be good enough as far as I am concerned. And so I stand here today and I propose that we engage in studies, surveys, we take narratives, we have community forums, and we educate ourselves so that we can be ready to be the U of I that provides the model for the rest of our state and quite possibly our country. And guess what? So much work has already been done. Thanks to national and international scholarship in every area. We know about bias that women and faculty of color face. We know about the type of bias that students of color face, that minority students face, whether it's a sexual minority, you're a religious minority, or you're a woman. We know this. We don't have to argue over it. And we've got enough studies to show us how to look at our own materials, whether it's our student evaluations, our faculty performance evaluations, and to figure out how to do a better job to create the community that people like me can thrive in, not just survive in. So there's much work for us to do, but I think we've got it in us to do this work. Remember, we are the land-grant university of this state. It is time for us to make sure everyone knows that we can provide the necessary leadership on the critical issue of diversity and inclusion. If we can't, I fear for the next century in terms of the viability of our university. We've got two beautiful law school campuses. We've got campuses statewide that I've had the pleasure of benefiting. And people always say to me, thank you so much for coming to U of I. And I want to say to them, I am proud to be a Vandal. So at this point, I want to open it up for Q&A. And if people have questions, feel free to raise your hand electronically, which you can do by clicking the reactions button and then raising the hand, clicking the raise hand button after that. For those of you who are on camera, you can just wave your hand physically. And if there's a ton of silence, you can just speak out. Rochelle Smith.
Thank you. So thank you so much. I wanted to ask, I know you were earlier when you were talking about the burden on students of being, let's say, if in a situation that's not very diverse in terms of being isolated, in terms of having to represent their entire group. I'm curious if there's been much conversation about its effects on education itself. And I'm thinking about like the idea of the studies that have been done about how many medical students think Black people don't experience pain the way white people do, for example. Is that part of the conversation around diversity, the idea that it actually ups the quality of your education if it's not just a really monolithic room where people don't have any other You know, I mean, if it's not just to the benefit of the students themselves or even the campus community, but to the professions they ultimately join.
Oh, of course. And I think it's clear that our country is going to continue to become more diverse. And not everyone will practice in homogenous communities. And so the studies have made clear that diverse education improves the profession. One of the more remarkable things about the University of Michigan litigation before the US Supreme Court is that we had what's called amicus briefs. And this is some legal mumbo jumbo, right? I think amicus is some Latin term that we use. I don't even know what the word amicus means, but either way, what you had were these outside groups who can get permission from the court to say, hey, I've got an opinion about this case. And we had a record number of amicus briefs in favor of the use of race in admissions practices. Everything from Fortune 500 companies to the US military branches to other really high profile industries and folks. And they all agree that a diverse education leads to better results in the field. That all the studies have shown that diverse team groups lead to better pitches to clients, right? Diversity just leads to better results. But I also think diversity is about enforcing our 14th Amendment Equal Protection Clause, which guarantees equal protection to everyone, but also is the clause that frees us all, right? And so I think in some ways, how can we honor the Equal Protection Clause if we're allowing discrimination to keep qualified people out of, and to keep us from diversifying in a way that is more reflective of who we actually are. I'll just say also, the studies are clear that the education outcomes are better when students are not isolated, when they don't have to deal with racially insensitive or harassing behavior. And so given the fact that most people are paying money for this educational experience, you have a economic substantive due process right to a discrimination-free environment. And so again, this honors our Constitution when we increase the diversity. And I, like everyone else, pray for the day when we don't have to have these conversations, right? When we just naturally attract diversity, right? But guess what? We're not there. And I'm not fortunate to live in those times. And we have to live in the reality that we have.
Thank you.
You're welcome. Thank you for your question.
Well, go
ahead.
Sorry, I assume that is the argument being made that that's better for white students too, or better for straight, white, male, able-bodied, what have you, students as well. I think that's part of what I'm curious about is because I feel like sometimes the argument, the way it gets framed, people are like, oh, that's something's gonna be taken away from me for this abstract diversity goal, as opposed to like, it's better for everybody, right? I mean, it's better for white students' education, not just Black students' education, for example. Sorry, not to keep timing.
Oh yeah, you know, I'm coming at the end of my 10th year here at the institution. And when I reflect back on the conversations that I've had about students, about diversity, inclusion, I am amazed that I get a large number of students who appear to me to be white, right? You never know anyone's ethnicity, so I would not assume. And often students who appear to be white males coming to talk to me about the culture, about the climate, and some of the concerns that they have. And it always occurs to me that people think, when they think of these issues, they think of women, they think of students of color, and they ignore that white men have just as much to say and just as much to contribute to the culture and the climate. But I think there's this weird desire to sort of ignore that white men have a role to play in this. And I think, again, for those who come to talk to me, they have a lot to say and a lot to contribute. And it is not a monolithic voice. And I often think that the voice of white men are sort of, stereotyped in many ways. But often that's because we don't open the forums, right? We don't create the space. When you create the space, you do see the diversity of thought amongst all students, right? Not every student of color has a difficulty. And yet we oftentimes have these conversations and interpret it as if that is true. That's not the case. And so that's why I think there's just a need for more engagement, more conversation, and more cross-campus conversation as well on these issues. I don't know a lot about the climate or the community at many of the different parts of our institution, right? I know a little bit about Moscow because I was there 3 years, and I know about Boise, and that's it, right? I'd love to hear from our colleagues up in Coeur d'Alene or in Twin Falls, which I'm assuming maybe we got to Twin Falls, maybe we don't, but let me say Pocatello, right? I would love to hear and have more community conversation from the other branches of our institution, because what we need in Moscow may not be what we need in Boise, right? What we need out east may not be what we need in Coeur d'Alene. And so we have to evaluate to come up with these location specific, but also there's a common goal that we have, which is to improve the culture and improve the climate at all locations. And we have to understand that we can never improve it enough. There's no sort of checklist and then we'll be able to sign it and put it in the file and say, we're done on diversity. No, this is work that you always do, because diversity always changes and the needs of your community on diversity always change. Any other questions? Don't be shy. As I tell my students, there's no such thing as stupid questions, only stupid answers. And since I give the answers and I'm the professor, they're all brilliant. So all your questions are brilliant as well. Julia Ames.
I just wanted to say thank you for your enthusiasm. I know I came in late. I apologize. I had another meeting before this, but I enjoy your enthusiasm and everything that you've had to say.
Thank you. Samantha, I can't see your last name. Parrott, Samantha Parrott.
Hi, Professor Sanders. Thank you so much for this wonderful talk. I really appreciated it. So I work in the fundraising department for the University of Idaho. And I think a key component to increasing diversity, of course, is scholarships. And we had a donor come forward who wanted to leave their entire estate to U of I to set up a scholarship that would benefit. They wanted to specify Latinx students. And the response from general counsel was that that's potentially problematic due to the state statute that you referenced. We ended up coming to kind of an agreement. And so the endowment agreement basically states that the scholarship will go to underrepresented populations. You know, it'll be up to, it's in the College of Ag, it'll be up to us, you know, to award it. But I just wanted to get your thoughts on that. And I also just your thoughts in general about our scholarship awarding process and how, what can we do to use scholarships to increase diversity? Because I think that's a huge key as well.
So first of all, what I want to say is thank you for the work that you do on scholarships. I know it's really difficult, and I don't have any expertise on that. So I don't want to in the answer. I certainly don't want to misrepresent in answering that I actually have expertise. But I think I have some ideas for you. One, I think that you need data, right? Get data to show that there may be a need, right? And so that's the one thing I'll say. Get narratives of your student experiences, all of them, right? So that you can talk about why you need more bodies in this. You need that critical mass, right? And I think if you have the data, if you have the narratives, if you have the numbers to back up what you want to do, then you make the argument that this is not discrimination and this is not preferential treatment. This is a remedy. And then you often you look at and what you really want to, and what the data will help you do is show the need for the remedy. Now, the data may not necessarily help you with the, is this remedy necessary, right? But getting to the need for the remedy and seeing what your data shows you is what helps you come up with the method of your remedy, right? And so that would be my first step. And I know there's a lot of fear to opening up these doors, right? Some people say, oh, then you just get everybody complaining, right? But we're professionals. We know how to evaluate complaints. That's what we do as professors and professionals every day, right? It's sift through different complaints. So I think we've got it in us to look and to see what this experience is. Oftentimes, what you can also show is retention. Those are some of the biggest issues, are retention. So do you just have too few students? Oftentimes, get to know some of those communities, right? And that way, what you can talk about is the needs of those communities. And that is what this is filling, right? This is not discrimination. This is a need in this particular community. And there, what you're doing is you're building partnerships, right? Which leads to everybody in that community wanting to come to your school. Then you don't need that for your critical mass. They're going to want to come anyway, because it's where everybody else goes, right? So I think that we have to build that loyalty in parts of our communities that are diverse. And I don't know if we've done that, right? I don't know if we've made it such that we're the choice. And if we haven't made it for why we're the choice, we need to find out why that is. And if it is because of a reputation about our culture or our climate, then, we need to be honest about that. It doesn't mean that we shut down. It just means we are honest, we are aware, and we're going to fix it. So I hope that's helpful.
That is very helpful. And I appreciated your earlier comment of, what are we afraid of? The time is now.
Okay. I think we've got time for maybe one more question, if there are any. I don't want to pressure anybody. It's only the second day of March after all. Jakari.
Hi, Professor. This question might be more about, I guess, and somewhat related to law. I'm at the law school at the Moscow campus. So sorry for anybody else who's listening, but when you're talking about the stuff with anti-discrimination, we've had like the common read that was done, I think between Moscow and Boise, if I'm correct, with Professor Kendi's proposal about anti-racism. How do you think that, and I know it's hard from a legal standpoint, how do you think that we can like try to work that more into the law? Kind of how you talked about the statute in Idaho specifically. It looks good on its face, but in a lot of ways it can bar things that you can do. So how can we work it in the legalese sense? And then also, how do you kind of like, start bringing in those conversations that like me and other students are trying to have with classmates who, I guess at the very least are not in the same train of thought as some people of color who come to these predominantly white institutions?
So I know for me, and I can only speak to the classes I teach as a professor, right? But in terms of being an anti-racist in the classroom, you better bet, right? One, the students are expected of me. Look at me. If I let it go, it is expected that you will not have that negative experience on that stuff in a Sanders class. Much of it is because I'm a Black woman. That's just the fact of the matter, is that people expect different things of you because of your race and because of your gender. So for me, it's very important to know that I'm living up to that, right? That I'm modeling how to deal with these issues. And also as a Black woman, I'm one of the few models of people of color on the faculty. And so I have to live up to that just for our students, right? Professionalism, as you know, is the linchpin of our profession. And so the ways in which I specifically do it, though, is to make sure that we talk about race in the class, even if it's not in the case, right? You can go look it up. There's something called the internet, and you can find out a lot of things on the internet. And so when you read a case and things are left out, you can actually go look it up And so that's what we do in a lot of my classes. I'm able to give you more background than what you're going to get in the textbook, right? And if there's a race or if there's a gender issue, I'm going to let you know. I also, or in socioeconomic issues are another one that I highlight. Those are great because it's not just about race and it's not just about gender, right? And so if there's a socioeconomic issue in a case that's not reflected, I'm going to try to find out and I'm going to try to let my class know. I also make sure not to skip the critical cases on race or gender in my classes. That is just not the choice you will find in a Sanders class. We're going to talk about Dred Scott, right? We're going to talk about Plessy versus Ferguson. We're going to talk about Korematsu. We're going to get in it, and it's going to be uncomfortable. I know, but guess what? Law is uncomfortable, right? You're going to probably have to go see your clients in a jail. That's uncomfortable, right? Sitting in your law school classroom talking about race in the grand scheme is not uncomfortable. It's part of the legal education. Why? Because race and gender discrimination are part of the law, right? It was part of our society. It was how we set up our society, right? We dispossessed people's land based on their race. And then we enslaved other people based on their race. And then we created a constitution, right? That constitutionalized all of that and kept others out. So that's just part of law. I'm sorry. Trust, I would love if we did not have all that part of our law. I will be the first in line to vote to say, yes, let's pretend like there was never any slavery, but I can't because it happened, right? So we have to talk about it. And in law school, it's just part of law as we've been reading, right, with our common read. And so we have to deal with it. But I think what you guys are doing as students is how you deal with it. For better or for worse, your law school classmates, you're going to be in contact with for a very long time. And you guys are going to be leaders, right? You're going to be writing the laws. You're going to be writing opinions. So you have to have some familiarity and some comfort on the subject if you're going to be legal leaders for the future. And that's what we're training you to be. And so I say just keep up the hard work with your classmates, but don't forget about the importance of self-care. Sometimes you cannot be part of all the conversations. Sometimes it's good for you not to be part of that conversation. Sometimes you have to protect your self, especially if other people are exploring and learning, right? It's okay for you not to be there, especially if you're often the only person of color or the only woman or the only whatever, right? Sometimes it could just be a benefit for the group that you are not there. So don't forget about self-care in this. If you're going to be doing this 20, 30 years down the road, you got to be here and you got to be healthy. But thank you for that question, and thank you for participating in the initiatives that we've started at the law school to bring more awareness of the need for diversity and inclusion. And I hope that was a helpful answer to your question.
It was, thank you.
Okay, so I think it may be time for us to wrap up our conversation today. I really want to thank everyone who was able to join me in this conversation. It was incredibly beneficial for me to speak to you and to form my thoughts. And I also just want to say to all of the students, feel free to reach out. You don't have to be just a law student to reach out. I'm professor, so if you didn't feel comfortable asking your question in this forum, you can certainly email me. You can find me on the law school's website. Trust me, you won't get me confused with anybody else on there. Trust on that, even if you don't remember my name. So feel free to just email me and I'll get back to you as soon as I can.